Let's be honest. You probably tell your AI everything. Your worries, your secret plans, maybe even things you wouldn't tell another person. But what if all of that could be dragged into a courtroom and used against you? Today we're diving into a really fascinating legal argument that asks a critical question. Should your conversations with an AI be legally protected or privileged? As you're about to see, the answer is a whole lot more complicated than you might think.
So let's just start right there. Have you ever used an AI chatbot to vent, to ask for advice, or maybe to explore a sensitive topic you just didn't feel comfortable discussing with anyone else? If you have, you are definitely not alone. It seems like we're all starting to treat these systems as our new digital confidants.
And there's no question about it, AI has become this new kind of confidant for literally millions of people. I mean, we're using it for everything from chats that feel a lot like therapy to getting some quick legal research done. And that, right there, raises a huge legal question.
Now, what's so interesting here is why we're all turning to AI. For so many of us, it feels like a safe space, you know? It's free of the judgment, or the stigma, or the seriously high cost that can come with talking to an actual human professional. Our chats with AI, they feel private. And that leads us to a really dangerous assumption, that they are legally private, just like talking to your doctor or your lawyer. But are they?
Okay, to even begin to answer that, we have to understand a core legal concept. It's called privilege. And this has nothing to do with special treatment. It's a very specific and very powerful protection in the legal world. And believe me, the bar to get it is incredibly high.
So evidentiary privilege is basically a legal shield. It lets you block certain conversations from ever being used as evidence in a court of law. But here's the thing, this protection is designed to be rare because it flies right in the face of the court's #1 job, finding the truth.
And this quote right here, it gets to the absolute heart of the matter. The entire U.S. legal system is built on this one idea, that for justice to work, courts need access to all the relevant evidence. So carving out an exception to that, letting someone hide evidence, is a massive deal. And it is not done lightly.
So for a privilege to even exist, courts demand that these 4 pillars are rock solid. First, it has to be a trusting human relationship. Second, the person you're talking to must have an enforceable duty of secrecy. Think about a lawyer who can literally be disbarred for blabbing. Third, the conversation has to be for a very specific protected purpose, like getting actual legal advice. And finally, the big one, society as a whole has to agree that protecting this relationship is more important than the evidence it might hide. You have to meet all 4. No exceptions.
All right, so with those 4 pillars fresh in our minds, we can finally tackle the big question. Can an AI ever qualify for this? Well, the core of the argument against it really boils down to this critical legal distinction, the difference between performing a function and having a relationship. Just take a look at this comparison. A human professional, well, they're licensed, they're accountable, they're bound by ethical oaths and these things called fiduciary duties. They can be fined, sanctioned, or even lose their entire career. An AI, on the other hand, it's a commercial product, it's just code, governed by a terms of service agreement that, let's be real, you've never read and can change it anytime. There's no real accountability. You can't disbar an algorithm or revoke its medical license.
And this is the killer analogy from the article that this is all based on. It's just perfect. A calculator performs the function of an accountant, right? It crunches the numbers. But nobody, and I mean nobody, would argue that your calculator entries should be legally privileged. In the same way, an AI might simulate the function of a therapist or a paralegal, but that simulation doesn't magically create a legally protected relationship.
So, when we actually hold the idea of an AI privilege up against those 4 pillars we just talked about, the whole case just collapses. Is there a human relationship? Nope, it's a tool. Is there an enforceable duty of secrecy? No way. Terms of service aren't oaths. Is there a specific protected purpose? Not really. User chats are a messy mix of everything. And is it vital for the public good? Well, there's zero proof that AIs need this to function. It fails on every single count.
But the argument doesn't even stop there. It turns out creating a new privilege for AI isn't just legally unsound. It would actually open up a huge can of worms and create some really serious problems for our legal system and honestly for public safety.
Seriously, just think about it for a second. Courts would get totally bogged down in endless fights over which AI chats are privileged and which aren't. People could intentionally try to hide evidence by just typing it into a chatbot, a practice some are calling privilege laundering. And this is a big one. It would make it almost impossible for regulators to look under the hood and audit these systems for dangerous biases or safety flaws. It's a recipe for chaos and a total lack of accountability.
So, if privilege is absolutely the wrong tool for the job, does that mean all our sensitive AI chats are just out there in the open with no protection? No, not at all. The article proposes a much smarter, way more flexible solution. And that's focusing on the idea of confidentiality.
This slide is so important. You see, privilege is an absolute all-or-nothing courtroom shield that protects a relationship. Confidentiality, on the other hand, is all about data protection rules. It's not about blocking evidence from a trial, it's about creating smart, modern rules for how our data is collected, used, and shared in the first place. It protects the data itself, not the relationship.
And here's what that actually looks like in practice. We can create targeted laws for high-risk areas, right? Like protecting data from mental health apps. We can use the consumer protection laws we already have to go after companies that make phony claims about privacy. We can require companies to minimize the data they keep, forcing them to delete our chat sooner so it's not just sitting on a server somewhere waiting for a subpoena. And hey, when cases do go to court, judges already have tools like protective orders to handle sensitive information. The point is, we don't need to break evidence law. We just need to build better, smarter rules for data.
And all of this leaves us with a final, really powerful question. Maybe we've been framing this conversation all wrong. Instead of going to the courts and asking for an old-world legal shield that was never designed for this kind of technology, maybe we should be turning to the AI companies and to our lawmakers and demanding something far more useful: real, robust, and actually enforceable privacy protections designed for the world we live in now.